We're going to try and get started. There may still be a few people straggling in, grabbing lunch, but we'll try and get started. They'll do that while I'm talking, not in court. So you'll all be here when Professor Mamdani begins. My name is Jim Cavallaro. I'm very happy to welcome you all here. I'm a professor at the law school, and I direct the Stanford Human Rights Center, along with my colleague, Vargas, sitting right here. We'd also like to thank the Stanford Center for African Studies, which has co-sponsored this event, and I understand has graciously rescheduled some of its own events so that those in that center are able to be here. Before I introduce today's speaker, I wanted to use this position briefly to tell you about some other events that you may find of interest. First, on Monday, this next Monday, we will screen Unmanned: America's Drone Wars, a film by Robert Greenwald, produced by the Brave New Foundation. Our Human Rights Plan, which I also direct, has worked closely with the producers of this film in conjunction with a report that we issued last September on drones and drone strikes in Pakistan and the consequences in terms of death, injury, and community disruption from the constant presence of drones in Pakistan and also drone strikes. So you may be interested in that. That's on Monday, and you will see posters around this building and the other buildings at the law school about that event. Second, on Tuesday, we'll be joined by Mahmood Mamdani, the dean at the SUNY Buffalo School of Law, who will consider the question, is the ICC hunting Africans? Mahmood is a very engaging, critical thinker and speaker that I believe many of you will find of interest. That talk will be Tuesday, next Tuesday at 12:45 in room 185 in this building. Finally, in January, we'll hear from James Anaya, the United Nations Special Rapporteur on the situation of human rights and fundamental freedoms of indigenous peoples. He's also a professor at the University of Arizona College of Law. All of these are part of our year-long series on the future of human rights. There are also some sheets circulating with, say, name and email. If you write your name and email on that, you will receive emails about future events regarding human rights, sponsored by the Stanford Human Rights Center. To today's speaker, who I think for this crowd really does not require any introduction at all. And I also know you're anxious to hear him, so I will be brief. I still would like to say a few words, beginning by thanking Professor Mamdani for graciously accepting the invitation to come to Stanford. We're honored and thrilled to have you here. Professor Mamdani is the director of the McCary Institute of Social Research. He's also the Herbert Lehman Professor of Government at the School of International and Public Affairs, and a professor of Anthropology, Political Science, and African Studies, all at Columbia University. He's the author of numerous books and articles. I won't need to list those. What I would like to say, since this is the Stanford Human Rights Center, that's the main organizer, is that Professor Mamdani's human rights and social justice goes way back. It's caused him to make personal sacrifices, including when he was arrested with other civil rights leaders in Birmingham, Alabama in the 1960s, or when he challenged his own government, leading him to deny him citizenship. So, in addition to being a person of the highest moral character, Professor Mamdani, I believe, and many others believe, is one of the sharpest thinkers and most powerful critics on issues of global politics in the world today. His writings have considered issues ranging from the topic we will address with us now to vital contemporary questions, including the politicization of the conflict in Darfur and the demonization of Muslims post 9/11. Voted one of the top 10 intellectuals in the world today, among other honors, Professor Mamdani is provocative and persuasive. If prior experience is any guide, you can be certain that Professor Mamdani's analysis and insight today will be piercing, and that sacred cows and conventional wisdom will be subject to rigorous scrutiny. Without more than, I'd like to ask you all, please join me in a warm Stanford welcome to Professor Mahmood Mamdani.
Thank you very much. It was beginning to sound like an obituary. If you think, as I do, if you think of the world from my father, as apartheid rule. Then you can be excused for thinking that you have now reached the end of the road. This is the West Coast. You couldn't possibly go any further west on the map. And that's what I wrote to a friend after I arrived there last night. I'm delighted to be there, and I thank the organizers for inviting me. I'm going to read the talk. My experience is that if I talk, then it usually takes long. And everybody's time is limited. The human rights movement of the late 1970s anchored itself ideologically in the lessons of the Holocaust and presented itself as a post-Nuremberg movement. Sam Moyn, a colleague at Columbia University, has recently argued that human rights were born as a moral criticism of politics, an alternative to a grand political mission. In this talk, I will seek to connect the moral and the political, the ethical and the historical, through a discussion of two responses to crimes against humanity. The first, Nuremberg, the criminal trials that followed the Allied victory in World War II. And then secondly, Codesa, Convention for a Democratic South Africa, the talks that led to the end of apartheid. The contemporary human rights movement anchors itself ideologically in the lessons of defeat, not of revolution. The lessons of the Nazi Holocaust, not the French Revolution. Whereas the movement organized around the revolutionary banner, Rights of Man, as it was then called, was highly political, the contemporary human rights movement is consciously anti-political, which is the meaning it gives to the notion of human and humanitarian. Nuremberg redefines the problem and the solution. The problem is extreme violence, radical evil, and the question it poses is that of responsibility for violence. The solution, encapsulated as lessons of Nuremberg, is to think of violence as criminal and of responsibility for it as individual. We are told that state orders cannot absolve officials of individual responsibility. Above all, this responsibility is said to be ethical, not political. Could one argue that the lessons of the transition from apartheid is the opposite? Should extreme violence be thought of more as political than criminal? I was part of the audience one gray morning in Cape Town when the TRC questioned F.W. de Klerk. De Klerk had just read out a statement enumerating the wrongs of apartheid and concluded by taking responsibility for apartheid. But the TRC was not interested. Its interest was narrowly focused on specific human rights violations, such as murder, torture, kidnapping. Did de Klerk know of these? Had he authored any of these? It struck me how different this was from what I had read of Nuremberg. At Nuremberg, the greatest responsibility lay with those in positions of power, those who had planned and strategized, not those with boots on the ground. At the TRC, the responsibility lay with the ones who pulled the trigger, those closest to the scene of the crime. Why was the leadership of apartheid not held responsible for it? The answer is political, not ethical. The negotiations that ended apartheid provide us with the raw material for a critique of the universal claims of the current human rights paradigm. I would suggest that the present rush for courtroom solutions advocated by the human rights community is the result of a double failure, analytical and political. Analytically, it confuses political with criminal violence. Politically, the focus on perpetrators is at the expense of a focus on the issues that drive violence. As such, it is likely to magnify rather than mitigate violence in the public sphere. What distinguishes political from criminal violence? The key difference is this. Political violence requires more than just criminal agency. It needs a political constituency. More than just perpetrators, it needs supporters. That constituency, in turn, is held together and mobilized by an issue. More than criminal violence, political violence is issue-driven. Nuremberg and Codesa need to be thought of as two responses to political violence. Each was a response to a crime against humanity. Each has an implication for how we think of human wrongs and thus of human rights. Whereas Nuremberg shaped the notion of justice as criminal justice, Codesa calls on us to think of justice primarily as political justice. Whereas Nuremberg has become the basis of a notion of victims' justice as a complement rather than an alternative to victims' justice. Codesa provides the basis for an alternative notion of justice, which I should call survival justice. Let me first talk about Nuremberg. Nuremberg was one of two trials at the conclusion of the Second World War. The second was the Tokyo trial. Nuremberg was an innovation for at least three reasons. The judges at Nuremberg rejected the claim that individual officials were not responsible for an act of state. Nuremberg established the principle of individual responsibility for the violation of human rights. The judges at Nuremberg also established criminal responsibility for these actions. Finally, Nuremberg stood for a universalism whereby, quote, the international community would be able to reach back through the boundaries of state sovereignty to protect individuals or enforce norms, thereby holding these individuals directly accountable to this same international community. The international community was a euphemism for a group of civilized nations, in quotes, to which otherwise sovereign polities were ultimately answerable. Nuremberg was born of a debate among victorious powers on how they should deal with defeated Nazis. Winston Churchill argued that Hitler and his gang had forfeited any right to legal procedure, and so should be summarily shot. Henry Morgenthau Jr., U.S. Secretary of the Treasury and a close friend of Franklin Roosevelt, agreed. Morgenthau went further and called for a destruction of German industry, so Germany would never again rise as a power. The opposition was led by Henry Stimson, Roosevelt's Secretary of War. Stimson wanted a trial, not just a show trial, but a trial with due process. His conviction was shared by the chief prosecutor of Nuremberg, Robert Jackson. Even if based on due process, Nuremberg needs to be understood as symbolic and performative. For a start, only the losers were put in trial. The victors appointed not only the prosecutor, but the judges too. On their part, the accused preferred to be tried by the US than by anyone else. They expected a fairer trial from Americans, who, unlike the victims, Jews, Russians, French, British, had had the privilege of pavilion seats during the war. They also expected softer treatment from the Americans, who were likely to be German allies during the Cold War. For official America, Nuremberg was an excellent opportunity to inaugurate the New World Order by showcasing the performance of how a civilized liberal state conducts itself. At a time when the air was full of cries for revenge, Robert Jackson told the audiences at Church House in London, a fair trial for every defendant, a competent attorney for every defendant. Nuremberg combined elements of both victor's justice and victim's justice. Victor's justice followed the outcome of the war. Victorious powers established a rule of law under which alleged perpetrators were tried. The notion that justice would follow victory was not new. It followed a long-established tradition of how we think of justice in the aftermath of victory. Be that victory the result of war between states, or revolution between classes, or a civil war of a different type. In every case, the assumption is that once the conflict is ended, there is a clear victor under whose power justice can be administered. The overall frame marks Nuremberg as a model for victor's justice. The accused at Nuremberg were charged with 4 crimes. 1, conspiracy to wage aggressive war. 2, waging aggressive war. 3, war crimes, violations of rules and customs of war, such as mistreatment of prisoners of war, abuse of civilians, etc. And finally, 4, crimes against humanity, including torture and slaughter of millions on racial grounds. The first thing striking about this case is that the conspiracy to wage war and its actual waging were defined as the principal crime, labeled crimes against peace. The Holocaust came last in this series of 4 crimes. The Allies were divided in this order. The French disagreed that waging war was a crime in law. It is, after all, what the states did. At the Tokyo trial, which took twice as long, partly because of long and substantial dissenting opinions, Justice Radha Vinod Pal of India argued that the charge of crime against peace was a case of ex post facto legislation, which served only to protect an unjust international order if there were no other workable provisions for peaceful adjustment of the status quo. Much later, in 1992, Telford Taylor, who had replaced Jackson as the chief prosecutor in the 12 remaining US-conducted trials in Germany, and who then had a distinguished career as professor of law at Columbia Law School, conceded that the court's judgment on counts 1 and 2 did indeed rely on ex post facto law. An even more serious problem arose from the fact that the victor's court was not likely to put the victors on trial. Would not Truman's order to firebomb Tokyo and drop atom bombs on Hiroshima and Nagasaki, leading to untold civilian deaths at a time when the war was already ended, would it not qualify as, quote, gratuitous human suffering and, quote, a crime against humanity, to use the language of the court? Had not Winston Churchill committed a crime against humanity when he ordered the bombing of residential working-class sections of German cities, particularly Dresden, in the last months of the war? Most agreed that the British policy of terror bombing of civilian areas killed some 50,000 and seriously injured another 780,000 Germans. Victims' justice, often thought of as an alternative to victor's justice, was in fact a complement to it. One of the charges against the accused was that they had committed crimes against humanity. The charge was first formulated in 1890 by George Washington Williams, a historian, a Baptist minister, a lawyer, and the first black member of the Ohio State Legislature, in a letter to the US Secretary of State, in which he documented atrocities committed by King Leopold's colonial regime in Congo, concluding that this was a, quote, crime against humanity. I've already pointed out that crime against humanity was last of the 4 charges against the accused at Nuremberg. As the trial proceeded, the emphasis on victims' justice began to diminish. The reason was political. As the Cold War developed, US policy towards Germany moved from a demand for justice to a call for accepting accommodation over punishment. The effect was most evident in the trial of Alfred Krupp, the leading German industrial magnate. The Krupp family had been manufacturers of steel since early 19th century, and Europe's leading manufacturers and suppliers of guns and ammunition by the First World War. They had armed Germany in 3 major wars. During World War II, the Krupps managed 138 concentration camps, ranged throughout Europe. All camps were privately owned by the Krupps. Alfred Krupps used slave labor from the camps and prisoners of war to build his factories, and provided Hitler's wars with money and weapons as a combination of investment and commitment. One of those charged at Nuremberg, Krupps, was released in 1951. His fortune restored, he emerged as a key player in the Cold War. There was little justice for victims at Nuremberg. When it came, it was political, and it was obtained outside the court. To understand the particular form that victims' justice took, we need to appreciate the political context that framed Nuremberg. Nuremberg functioned as part of a larger political logic shared by the victorious Allied powers. This was that winners and losers, victims and perpetrators, must be physically separated into separate political communities. The Allies redrew boundaries and transferred millions across borders. In the process, Allied powers carried out or sanctioned the most extreme ethnic cleansing in modern history. The possibility of victims' justice flowed from the assumption that there would be no need for winners and losers to live together after victory. The perpetrators would remain in Germany and the victims would depart for another homeland. Yesterday's perpetrators and victims will not have to live together, for there will be a separate state, Israel, for survivors. The state of Israel was created after the principal trials at Nuremberg, but it was the culmination of a process that defined the logic of Nuremberg. Indeed, post-Holocaust language reserves the identity survivors only for yesterday's victims, as in Israel. This is also the case in contemporary Rwanda. In both cases, the state governs in the name of victims. We're going to talk about South Africa. The post-apartheid transition in South Africa is popularly identified with the work of the Truth and Reconciliation Commission, the TRC. This work is presumed to have been guided by the dictum that those in power must forgive past crimes in return for acknowledging the past, meaning truth. It is said that the TRC created a new precedent: immunity from prosecution in return for acknowledging the truth, forgiveness in return for an honest confession. As the saying goes, forgive but do not forget. This claim is central to the contemporary ideologization of the TRC. The problem with this widely accepted notion is that it is not quite true. Key to the post-apartheid transition was not an exchange of amnesty for truth. The fact that the amnesty was granted in exchange for the willingness to reform, that reform being the dismantling of juridical and political apartheid. The real breakthrough represented by the South African case is not contained in the TRC, but in the talks that preceded it and were known as the Convention for a Democratic South Africa, Codesa. These talks have so far been dismissed as nothing but so much hard-nosed pragmatism. The ground for Codesa was prepared by a changed mindset. Both sides recognized that there was little prospect of ending the conflict in the short run. For the leadership, this was equivalent to a recognition that their preferred option was no longer within reach. Neither revolution, the liberation movements, nor military victory for the apartheid regime was in the cards. If South Africa is a model for solving intractable conflicts, it is an argument for moving from the best to the second best alternative. The second best alternative was political reform. I suggest that we think of Codesa less as an alternative to Nuremberg than as a response to a different set of circumstances. As such, it is also a statement that Nuremberg cannot be turned into a universally applicable formula. Codesa was born of the realization that the conditions that obtained in apartheid South Africa were different from those that led to Nuremberg. The difference was twofold. First, whereas Nuremberg followed a military victory, the conflict in South Africa had not ended. How do you stop a conflict that has not ended? How do you convince adversaries that it is in their interest to stop an ongoing conflict? Surely, this could not be done by prioritizing criminal justice and threatening to take the political leadership on either side, the apartheid state or the anti-apartheid movement, to court. Because the people you would want to take to court are the very people you would need to negotiate an end to the conflict. Second, whereas Nuremberg was informed by a logic of ethnic cleansing, one that called for a physical separation of yesterday's perpetrators and yesterday's victims into separate political communities. In South Africa, there was no question of creating an Israel for victims of apartheid. Instead, it was clear that victims and perpetrators, blacks and whites, would have to live in the same country. Rather than put justice in the back seat, Codesa presents us with a radically new way of thinking about justice. It presents us with a double breakthrough. To begin with, Codesa distinguished between different forms of justice: criminal, political, and social. It prioritized political justice, the reform of the political system, over the other two. The difference between political and criminal justice is twofold. One, political justice affects groups, whereas criminal justice targets individuals. Two, the object of criminal justice is punishment. That of political justice is political reform. A shift of logic from the criminal to the political led to decriminalizing and legitimizing both sides to the conflict. The liberation movements, the ANC, the PSC, and the Communist Party were all unbanned. The apartheid regime, the Nationalist Party, and the highly secretive underground network known as the Broederbond also ceased to be treated as pariah by the anti-apartheid activists. In decriminalizing and legitimizing opponents, Codesa turned enemies into political adversaries. In the process, Codesa also changed the goalpost. The goal was no longer the internment and punishment of individuals charged with so many crimes, but a change of rules that would include them and their constituencies into a reformed political community. The consequence of criminal proceedings would be to remove those charged from the political process. The point of political reform was the opposite, to bring them into the political process. The full impact of this change in perspective was no less than a shift of paradigmatic significance. Whereas Nuremberg was backward-looking, preoccupied with justice as punishment, Codesa sought a balance between the past and the future, between redress for past and reconciliation for the future. The paradigm shifted from one of victims' justice to that of survivors' justice. The very meaning of survivors changed from a victim-based identity to include all those who had survived apartheid. Yesterday's victims, yesterday's perpetrators, and yesterday's bystanders or beneficiaries. The negotiators at Codesa faced a central challenge: how to forge a transition from a white minority regime to a government elected by an enfranchised majority. As an interim measure, parties to the negotiation agreed to lay down a set of constitutional principles that would define the parameters of the interim constitution. The negotiations at Codesa proceeded by way of horse trade, with each side trying to strengthen its hand through political pressure, including violence outside the negotiating chambers. Let me just go over a little bit of the highlights of what followed. Codesa assembled in December 1991 and broke up in May 1992. During that period, each side tried to muster a consensus within its ranks, and if not a consensus, at least a clear majority. The white minority took the lead. When the ultra-right-wing white conservative party won a by-election in Potchefstroom after the start of Codesa, the National Party government called for a whites-only referendum in March 1992. The government interpreted that victory as a mandate from the white population to continue to negotiate a political end to apartheid. The ANC responded to the whites-only referendum with rolling mass action of men and mass stairways of June 12. The result was a record of understanding on 26 September 1992. This was an agreement that a democratically elected assembly would draft the final constitution, but within a fixed time frame and within the framework of constitutional principles agreed upon by a meeting of negotiators appointed by all parties, but in reality driven by the principles, the NP and the ANC. The ANC cleared the ground for agreement with historic concessions, famously known as the Sunset Clauses, announced by Joe Slovo, the Secretary General of the Communist Party, in an article in the party journal, The African Communist. The article, clearly bearing an imprint of both the Communist Party and the ANC, called for power sharing between the two sides, retention of the old bureaucracy and of other organs of the state, such as the police, the military, and the intelligence services, and finally, a general amnesty in return for full disclosure. Joe Slovo did not need to state the obvious, that the real pro quo for these concessions was the dismantling of juridical and political apartheid and the introduction of electoral reforms that would enfranchise the majority and pave the way for majority rule. An acceptance of the Sunset Clauses would mean that South Africa would not have its own version of Nuremberg. The multi-party negotiation process began on 5th March at Kempton Park, but was sluggish. It took another political crisis to generate momentum. That crisis was the assassination of Chris Hani on April 10, 1993. The shared sense that storm clouds were indeed gathering made it possible to truncate discussions, especially those on fundamentals, such as the constitutional principle, and even the Constitution itself. Power was ceded to technical committees with assistance from the Herbert negotiation process in the name of preventing and breaking deadlocks in the negotiations. A procedure evolved called sufficient consensus. It had previously been adopted in the drafting of Namibia's 1982 constitutional principles, and it allowed the ANC and the NP to meet outside the formal discussion and define agreement on key issues. This combination of binding principles agreed upon by unelected negotiators and the power of the Constitutional Court to throw out a constitution drafted by an elected assembly was acknowledged by many as a blatant curb on majority rule, but at the same time as necessary to attain majority rule. The constitutional principles included a number of key provisions. Most important for our purposes was the Bill of Rights, which included protection of private property as a fundamental human right. At the same time, and without a stated rationale, the clause providing the restoration of land to the majority population was placed outside the Bill of Rights. where property rights were in clash, is that of white settlers and black natives. The former received constitutional protection, the latter only a formal acknowledgement. More important concessions were made at the local level. The Local Government Transition Act of 1993 entrenched consociational government at the local level. Local government elections were structured in such a way that they precluded black voters from obtaining 2/3 majority on a local government council. At the same time, the ward limitation system guaranteed non-blacks 30% of the seats. And another provision in the same law required a local authority to muster a 2/3 majority to pass its budget. The combined effect of these provisions was that local authorities in former white areas could not take any significant decision without the agreement of councillors representing white residents. Similar provisions entrenched white privilege in small towns. Another clause in the law required that local government taxes and levies had to be based on a uniform structure for its area of jurisdiction. This clause effectively prevented new local governments from taxing white areas to spend more revenues in black areas. Thus, Codesa entrenched white privilege, both in the Constitution and in the law that established the framework of local government. There are two debates in South Africa. The first focuses on the perpetrator, and thus on criminal justice. The second focuses on the beneficiary, and thus on social justice. Whereas there is hardly a popular demand in contemporary South Africa for perpetrators of apartheid to be tried and punished, it is the debate around social justice that more and more drives the critique of the post-apartheid transition. The current debate on the call for social justice needs to be taken as a double critique of both Codesa's success in putting a constitutional closure on the search for social justice and of TRC's failure to reopen that debate. Unlike Codesa, the process guided by the TRC was designed as a civic education process. TRC recommendations were not to have the force of law, but were rather to be considered as advisory in the policy-making process. Its advisory nature gave the TRC great flexibility, great latitude than it would otherwise have had. For it gave the TRC freedom to think a step beyond Codesa and thereby rethink the future. Such a rethink had the potential to connect the quest for political justice to that for social justice. The TRC functioned as a surrogate Nuremberg. It displaced the logic of crime and punishment with that of crime, confession, and amnesty. The TRC attempted to join the metaphor of political injustice with that of crime, but the attempt was not successful. The TRC sought to hold individual state officials criminally responsible for those actions that would have been defined as crime under apartheid. Put differently, it did not hold them accountable for the violence undergirded by the rule of law under apartheid, but only for infringements of apartheid law. The legislation that set up the TRC gave it the freedom to define the victim. In interpreting the legislation, the TRC made three key decisions. First, the TRC individualized the victim. To do so was to ignore precisely what was distinctive about apartheid, that it was a system based on group oppression. Second, the TRC defined a human rights violation narrowly as violating the bodily integrity of an individual. This distinction too proved problematic in a context where most violence was extra-economic. It was not due to the body, but the possessions of the body. The violence of apartheid did not target the bodily integrity of population groups defined as Bantu, but their means of livelihood, land, and labor. Finally, this extra-economic coercion, whether the forced removal of millions from land gazetted as white areas, or pass laws that tracked the movement of all black people, was the work of the apartheid authorities and not individual operatives. Just as victims were identified as racialized groups and not individuals, the perpetrators too were part of a racialized power, and not just individuals. A widely distributed and cited investigation by the Surplus People Project documented that 3.5 million persons had been forcibly moved by South African authorities between 1960 and 1982 as part of the project to create ethnic homelands. The Commission accepted the estimate and noted that forced removals were an assault on the rights and dignity of millions of South Africans. Nonetheless, the TRC claimed that these violations, and I'm quoting, may not have been gross as defined by the distinction between bodily integrity rights and subsistence rights echoes a familiar distinction in social theory between the realm of the political and that of the economic. Where a command economy obtained the familiar distinction between the political and the economic obscured practices, where political power directly intervenes in the sphere of economic relations, like slavery, coerced labor, and forced removals, coerced labor and forced removals required the direct and continued use of force. They could not be dismissed as structural outcomes lacking in agency and therefore not signifying a violation of civil rights. Rather than an outcome of the dull compulsion of market forces, to use a formulation of Marx, these practices were characteristic of extra-economic forms of coercion. Rather than illuminate the divide between the economic and the political, they tended to articulate the relationship between the two. Then there was the question of distinguishing political from non-political motives. Were pass laws the backbone of a legal regime that targeted every black South African? Political. Were arrests under pass laws political? According to estimates made by the South African Institute of Race Relations, over 1 million people had been administratively ordered to leave the urban areas by 1972. But the Commission refused to focus on those indicted under the pass law, or on farm prisoners, or on prisoners detained without trials, on the grounds that they were all common law prisoners and not political prisoners. When the public outcry grew against the Commission's decision to exclude from the hearings all violence that had targeted groups and communities, the TRC responded by holding institutional hearings, but then specified that these were to clarify the background, the context against which specific violations were committed. The Commission thus distinguished between structural and willed outcomes. The former reduced to context and background, and the latter highlighted as evidence of agency. To make the point, distinguish between bodily integrity rights and subsistence rights, individual and group rights, and political and non-political motivations, ruling that only politically motivated violations of bodily integrity of individual persons fell within the legislative purview. Past laws and forced removals, both targeting communities and not individuals, had been at the heart of the claim that apartheid was indeed a crime against humanity. But in the report of the Commission, both were reduced to background and context. At the end, the Commission came up with three truly bizarre conclusions. The first was a list of 20,000 plus names of individuals it acknowledged as victims of gross violations of human rights. The TRC recommended only those, and not the millions of victims of past law, forced removals, and forced labor, to receive reparations from the post-apartheid state. Second, the Commission compiled a time series of violations over its mandate, which began with the Sharpeville massacre in 1960 and closed with the first democratic elections in 1994. Most violations, the Commission concluded, took place in the period after the unbanning of political parties, which is 1990 to 1994, and that it was the result of conflict between anti-apartheid groups, especially the ANC and the IFP in Natal. From this followed its most scandalous conclusion, based on a list the Commission compiled of perpetrator organizations. The Inkatha Freedom Party was identified as the top perpetrator organization, with the ANC as the third top perpetrator organization. In this list of perpetrators, the state security services came as runner-ups. the South African Police second, and the South African Defence Forces trading is fourth. In sum, the TRC set aside the distinctive violence of apartheid, the violence that targeted entire groups and that was central to realizing its political agenda. This is because the TRC understood violence as criminal, not political, as targeting identifiable individual victims, not entire groups. It focused on violence as excess, not as norm. It thus limited the criminal responsibility of individual operatives to actions that exceeded political orders, actions that would have been defined as crimes under apartheid law. In doing so, the TRC distinguished between the violence of apartheid, pass laws, forced removals, and so on, and the excess violence of its operatives. Because it did so, it was unable to archive even that which Nuremberg did, to compile a comprehensive record of the atrocities committed by the apartheid regime. This is why the TRC should be seen as a special court within the framework of apartheid law. As interpreted by the human rights movement, the lesson of Nuremberg is that criminal justice is the only politically viable and morally acceptable response to mass violence. Nuremberg is today the model for the International Criminal Court, held as the fitting antidote to every incident of mass violence. To de-ideologize Nuremberg would be to recognize that the logic of Nuremberg flowed from the context of interstate war, one that ended in victory for one side, which then put the losers on trial. The logic of a court trial is zero-sum. You are either innocent or guilty. This kind of logic ill-fits the context of a civil war. Victims and perpetrators in civil wars often trade places in ongoing cycles of violence. No one is wholly innocent and no one is wholly guilty. Each side has a narrative of victimhood. Victims' justice is the flip side of victors' justice. Both demonize the other side and exclude it from participation in the new political order. A civil war can end up either as a renegotiated union or as a separation between states. The logic of Nuremberg drives parties in the civil war to the latter conclusion. Military victory in the separation of yesterday's perpetrators and victims into two separate political communities. That the founding movement of the South African transition is not a criminal trial, but political negotiations, is mainly the result of a radically different context. Apartheid was not a war between states. It was a civil war. The contemporary human rights movement is permeated with the logic of Nuremberg. Human rights groups focus on atrocities for which they seek individual criminal responsibility. Their method of work has a formalized name, naming and shaming. The methodology involves a succession of clearly defined steps: catalog atrocities, identify victims and perpetrators, name and shame the perpetrators, and demand that they be held criminally responsible. The underside of the focus on perpetrators is to downplay issues. Read the field reports of Human Rights Watch or International Crisis Group, and you will find that except with a pro forma 1-2-page introduction on history and context, the focus is on name and shame. Indeed, context is considered a distraction from establishing the universality of human rights. This is problematic. If one recognizes that political violence is often not a standalone incident, but part of a cycle of violence, a fact which is obscured if you ignore historical context. In a previous book on the Rwandan genocide, I set about constructing an historical account of the violence. The more I did so, the more I realized that victims and perpetrators tended to trade places. Where victims and perpetrators have traded places, each side is a narrative of victim. The more you downplay context, the more you tend to locate the motivation for violence in either the individual psychology of the perpetrator or the culture of a group of perpetrators. The tendency to portray the perpetrator as the driving force behind the violence leads to the assumption that the perpetrator is always the perpetrator and victim is always the victim. The result is to demonize the agency of the perpetrator and diminish the agency of the victim. Demonizing goes along with branding and reinforces the assumption that you can easily and eternally separate the bad from the good. The more depoliticized our notion of violence, the more the tendency to seek the explanation for violence in the person of the perpetrator. From being a problem, violence also becomes the solution. We think that eliminating the perpetrator will solve the problem, instead of showing a way out of the dilemma. This mindset feeds the logic of revenge, and thus the cycle of violence. But violence is not its own explanation. To break out of the cycle of violence, we need to displace the victim narrative with that of the survivor. A survivor narrative is less perpetrator-driven, more issue-driven. Atrocities become part of a historical narrative. They are no longer seen as so many standalone acts, but as parts of an ongoing cycle of violence. To acknowledge that victim and perpetrator have traded places is to accept that neither can be marked as a prominent identity. The consequence is to demonize and thus to humanize the perpetrator. If Nuremberg has been ideologized as a paradigm, the end of apartheid has been exceptionalized as an improbable outcome produced by the exceptional personality of Nelson Mandela. It is thus said that Africa's problems, the violence of civil wars, require a different solution, one approximating Nuremberg-type criminal justice, calling for punishment rather than political reform. But African conflicts are in the main civil wars. They are not in the state conflicts. The lesson of South Africa is to look for the solution within the problem and not outside it. The point is to strive for internal reform, not external intervention. Codesa has a double significance. Codesa focused on the cycle of violence as threatening the very foundation of a political community. It presents us with a challenge. It dares us to reimagine the political community by recognizing in the after effects of violence an opportunity to refound the political community. In doing so, it underlines the need to return to an older tradition in political theory, one that recognizes productive possibilities in political violence, especially civil war, by seeing it as potentially foundational to the creation of an inclusive political order. On the negative side, Codesa and the TRC failed to acknowledge that this same violence has been foundational to the establishment of a liberal socio-economic order. In the words of Marx, this extra-economic violence was key to primitive accumulation. The downside of the South African transition was its attempt to put a political lid on a public conversation about social justice in post-apartheid South Africa. It is arguable that the balance of forces that shaped the post-apartheid transition also defined its limits, a limitation reflected in the fact that the transition was more political than social. This should have been all the more reason to expect a non-binding process like the TRC to expand room for a discussion on social justice. Let me conclude. Codesa should warn us about the pitfalls of seeking victims' justice. In the absence of victory, victims' justice requires an external intervention. More likely than not, it sets you up for the next cycle of violence. The lesson is to shed the zero-sum logic that characterizes both the battlefield and the courtroom, and to seek inclusion through the reform of the political community in which yesterday's victims, perpetrators, bystanders, and beneficiaries may participate as today's survivors. The object of political reform is not punishment, but a change of rules, not state creation, but state reform. By turning its back on revenge, it offers the possibility of creating new communities of survivors. Reconciliation cannot be between perpetrators and victims. It can only be between survivors. The point is not to avenge the dead, but to give the living a second chance.
have 2 microphones set up, and please feel free to go up to one of them or take it off and we can move them around. I just ask you, please, in the interest of time, to be succinct and to indicate who you are as you raise the question. The mic's Yes, sir. Yes, sir.
I understand that you talk that if a society is looking like into the future, they should strive for the political justice rather than the criminal justice. But my question is, in some cases, the victims won't feel like there's been some justice performed. They want to see something tangible. They want to see someone behind bars. So is it possible to have a hybrid of the two? Forms of justice where perpetrators face justice, but at the same time they are still having
Well, the most famous case was the murder of Steve Biko. The facts were well known. The identity of the police. The family of Steve Biko took the police court, and the highest court in the land dismissed the grounds that not the facts were right, but that the interests of the larger family, the end of a party, required that the victim's demands not be given by. So my answer is basically maybe possible in some instances. But I think more often than not, it would not be possible. The interests of the whole, I think, must the interests of the state.
Other questions, comments? Okay, you are back.
Professor Mamdani, I just had a question about Rwanda specifically. To what extent do you think Rwanda and Kagame has been successful in turning its back on revenge and creating a new Rwandese identity out of this example?
That's another lecture.
When will it be? So we know when.
I think the Rwandan response, the Rwandan state's response is highly important. Basically, the Rwandan state's response has been to monopolize political power in the hands of the minority, to criminalize any public discourse which is understood as ethnic, to basically allow it only within the confines of the home. It's the exact opposite of Burundi. I mean, I think it's interesting to contrast Rwanda. Burundi, where the solution was driven very much by South Africans and Tanzanians. In the case of Burundi, the identity of Hutu and Tutsi not criminalized, but actually publicly acknowledged as the basis for the creation of the new state. So that every key state institution, whether it's the parliament, the cabinet, the civil service, the army, the officer corps, recruitment in all of these is important. The point is to ensure representation of Hutu and Tutsi, not necessarily according to population numbers, because representation is often 40% and 60%, 45% and 55%, or rotation. I'm not saying that the Burundi jump is necessarily bad. But I'm saying that the Rwandan route has precluded political reconciliation. And that's the most problematic side.
Madam Chair first.
You make a strong case about the differentiating between the direction of Nuremberg and Codesa. There's a bit of a puzzle on the South African side because you also draw a contrast between the TRC and Codesa. The one is insisting on corporate responsibility, the other on individual responsibility. But I'd like you to talk a bit more about the broader frame in which all this sits. The Codesa model that you've offered effectively is running against the grain at the global scale. At the global scale, we see an effort to attribute outcomes to individuals, not to hold people corporately responsible. And I take as the example for the moment all across North Africa, the support for those who are attempting to change things in the name of a subset of individuals, not a corporate responsibility, and certainly not an effort as the African Union pushed to find ways for people who are formerly enemies to live together. It seems to me what I would like to hear a lot more about in your telling of this story is what's happening at a global scale that makes room for the Codesa, or doesn't make room for that Codesa model.
Of course, you're right. Speaking against the first. And I stated this at the very outset. The presumption in the book is in favor of war, humanitarian intervention, or in favor of post holding individuals accountable. So I'm not claiming I'm reading you the good news from that Gallup poll I did around the world. But I'm giving you an argument against this consensus. I'm basically saying, I'm not giving you the one-size-fits-all solution. I'm saying it depends on the circumstances. And I'm distinguishing between two different kinds of circumstances. An interstate war, a war between states, and a civil war. I do not know of a civil war which was settled in court trials. Even civil wars which were won, where there was, let's say, some political wisdom, court trials were avoided. Take the American Civil War. The first copy until the Chinese Revolution, the most destructive civil war of the day. At the end of the American Civil War, there there were demands for court trials, but there was only one court trial, actually. The only trial was of the commander of Fort Anderson. And he was tried for treating the white Northern soldiers the same as the American Jews. Very different. He was, the logic of that trial was that there will be no trial of defeated Southerners because they will be treated as citizens, not as enemies. American Indians were enemies, not citizens. You couldn't treat citizens as enemies. That was the basis of the trial. Well, what I'm saying to you is that Nuremberg is set up to try enemies. The logic of Nuremberg turns yesterday's, not necessarily citizens, but co-residents in a single political community, into enemies, and drives them to set up separate political entities. The argument is that would be a disaster. Hutu and Tutsi cannot live in two separate countries. Maybe one day they will be. If we have any option, that's not the option we should choose. White and black, all over Africa, you have one or another version of civil conflicts, which come directly out of the kind of colonialism we live in. These conflicts are all informed by who is a citizen, who is not, who is indigenous, who is not. The notions of indigeneity, which were yesterday focused only on questions of race, are now focused on questions of race. Even in a village, you can have arguments about who is indigenous, who is not. And why are these focused? I'm saying court trials are not an response. They're a counterproductive response. They feed the cycle.
Yes, Professor Mamdani. I was thinking of the current problems that are beginning to develop in Mozambique, where there has been a Codesa type of process back in the early 1990s between the Civil War participants, the Frelimo and Renamo. And more recently, Renamo has made a statement without a lot of external support, as was the case before. Apartheid, South Africa, that they are going to engage in violence against the Frelimo government in Mozambique. And there doesn't seem to be a recognition on the part of Renamo leadership, of an acceptance of that political settlement. And I just wondered if that means that the Codesa model is not appropriate in certain circumstances. What another case would be Angola, but that would be even different.
Good. I've often thought of Mozambique and the settlement that came, which was very soon after Codesa, and followed Codesa, is actually for Ugandans an alternative to the way Uganda has pursued the LRA question. Because Renamo was a movement very similar to in terms of the tactics it employed to recruit, in terms of the child soldiers. And the interesting thing was that the political settlement in Mozambique made it possible for the leadership of Renamo to sit in parliament rather than behind bars. And it ended the violence for a long enough period. Now that settlement is in doubt. There are different views on why it's done. There are those who think that it's in doubt because the leadership of Freddie would like to have a third term, would like to stay in power, and wants to stay in power, and actually sees a rekindled civil war, or the threat of one, as positive to realizing its own agenda. I don't know, but so whether the responsibility for not honoring the settlement lies with this side or that side, with Filippo or Kanam, that to me is not reason enough to challenge the notion of political settlement. After all, settlements don't last. They're not eternal. The settlement can last 2 decades. That's not that. So I don't have an answer to what should they do. Because I think there's more here than just that.
So I think with that, we're going to have to wrap up. It's almost 2 o'clock, and again, if you can join me once more in thanking Professor Mamdani.